Hi everyone, my name is George and I'm a third seat trainee in Osborne Clarke's Bristol office. My current seat is commercial disputes and that's my second dispute seat that I've done, my previous seat being property disputes. In terms of a day in the life of a disputes trainee, I think like with many other departments, there's not really a typical day, but some of the key tasks that you might get involved with as a trainee are assessing a claim when it initially comes in, whether our client is the claimant or the defendant, looking at documentation that's been provided and using that to kind of make an initial assessment of the position and also prepare, if appropriate, instructions to a barrister. There's also quite a lot of legal research in the seat, so whether it's part of that initial assessment or issues of law and procedure that come up throughout the case, there's quite a lot of looking at specific points in the first instance as a junior and preparing internal advice notes for the supervisors on that matter to take forward. Depending on the fortune of timing, I've actually, across my two dispute seats, attended a number of case management conferences and also a full final trial, and that is a degree of luck as to what comes up in your 6 months, but you'll definitely be able to get involved at various stages of litigation and potentially at least preparation for hearings like that. I think one thing that people might not know until they do a dispute seat is that not everything that we do is always in the context of a dispute. So for example, in my property dispute seat, we gave some best practice advice about the acceptance of electronic signatures for one of our energy and utilities clients. It was in the context of what might happen if a dispute about an agreement which had been electronically signed was to arise in the future, but there was no dispute at that moment, and it really was a matter of best practice from a disputes perspective. And I haven't personally been involved, but I've also been aware of in this seat one of the partners looking into drafting terms and conditions for one of our fintech clients. Again, from a best practice perspective, there's a duty of care that arises out of case law and it's looking at excluding that. So not everything will always be fully in the context of a dispute, and that's something that I only appreciated having done the seats.